Okay. Can you hear me in the back? Great. So, a few months ago, well, last year, Ernie Barker died, and he was beloved by all of us. And Ricky, his widow, found some surprises that she thought things were pretty organized, and it turns out there were things that they could have done more. And so she wanted to share the things that she went through to help others. And Howard Katzman grabbed me and put me together with Ricky. And so we're ready to present this to you to help, hopefully, all of you can learn at least one or two things today that might help you in your own lives. We have more outlines coming from the office, and they'll come into the back of the room for you. The outlines are to help you to remember what we said so that you can just make some notes, but things are pretty much written down there. And there are some handouts that you can come and get later on. So I'm going to turn it over to Ricky to start.
Well, hi, everybody. Can you hear me back there? Okay. Well, I wanted this class because it was important to me to honor Ernie. And the lessons that I learned in this class going through the process really helped me know that I had to pass this on to other people. In our home, Ernie took care of all of our finances and he managed the boat. It left me free to earn a living and pursue my hobbies. That all changed 6 months ago when he came to the boat and said he was having problems with thinking. And he had to teach me everything he could about our finances and taking care of the boat. He brought his friend in to help, and he even gave him power of attorney over his life because he was afraid that if I should die before him, there would be nobody to take care of him. Well, Ernie died and I lived, and his friend became my advocate. My advocate helped me navigate the reams of paperwork that were required after his death and all the unexpected glitches that came up. And so that became the basis of wanting to pass this on to other people so that you wouldn't have to go through things that I did. So with that, I want to hand it back to Vicki so that she can give you some more information.
And Joel Leslie told me to let you know that they're taping and recording this session. So you all give your permission, right? One of the things that is clear with Ricky is that even sophisticated people who think they have things, the outlines can just go in the back of the room. People can pass them around, please. Even when you're sophisticated and you think you have everything together, there are things that are forgotten. And so Ricky, through all of her emotions today, is going to try to help you to see what happened with her and be open with you. And I must say that even when a spouse dies, there's mounds of paperwork and hurdles to surmount. And if you're with someone who's a significant other and not a spouse, then you have no legal rights. And it's like triply important to get things in line so that the right people have the right control and power.
I just want to add one thing. If you see me cry today, that's okay. I'm still going through the grieving process, but what's most important to me is that something we cover today is going to help you in the future. So I just wanted to add that. Don't worry if I cry.
But do worry if I cry. Okay. So
yeah, I've got my tissues.
So let's talk about, let's go down to basics. So where are the financial assets? In most marriages and relationships, one spouse takes care of the finances and the other one does other things. And so you want to be sure to have a list of where things are, where your bank accounts are, where your brokerage accounts are, who the beneficiaries are. One of our handouts that Ricky brought in is a listing for financial assets and why don't
It's
you talk
it's
about,
pretty detailed, and I've been instructed to make sure that I share this not only with my attorney, but with my advocate so that they know exactly who to contact and how to contact them.
many times I will encourage my clients to make a list of where their accounts are. It doesn't even matter how much value or money is in an account, but just where they are in Bank of America at this branch and Merrill Lynch at that branch, because or who their financial person is, so that if something happens to them, incompetence like an accident or death, then there's a list of something and the family doesn't have to go sleuthing through files and drawers and so forth. And so it's good to give someone that. Now, passwords are a new topic that's come up these last 5-6 years, because someone dies and then what are their passwords and how do you get into anything?
Yeah, I can speak to the passwords because Ernie had pages of passwords, not only for ourselves, but for the club. And because he didn't realize he was going through these mental problems, many of the passwords were incomplete or he'd forgotten to put them on the pages. And so it forced me, going through this grieving process, to check each of these passwords to make sure they were current, or keeping his phone active because everything was set up to go to his phone. And the only way I could retrieve information was to keep that phone active. And I had to go through and check every password, and then things would come through that I had no idea that we had. So we didn't have the communication. We always meant to talk, but we always put it off like all of us do.
So you need to figure out how you can save your passwords to communicate them, whether it's on paper or under a password manager. That's way beyond what the two of us can talk about today. But I think that you can read up and think about how to do that in a sophisticated or an unsophisticated way so that things don't just get locked up and you're lost. Talk about credit freezes from your problem with the credit card.
Yes, when Ernie and I got married, he had already had a bank account set up. And this to me was one of the most important lessons I learned is I put my assets in with him. I had a credit card with my name on it. Our checks had my name on it. But when the bank was informed that he died, they put a hold on his account and they canceled all the credit cards. I was at the grocery store and the card came back unauthorized. It took me weeks to try to get a death certificate so I could get access to the bank account again. But the credit cards required that I get a credit check and open a brand new credit card. What I found out after hours on the phone was my husband was considered the sole owner of our bank account. And upon his death, everything was canceled. And to get a new credit card required that I go through a credit check, which sounds good. But unfortunately, we were concerned that we would lose, somebody would open accounts in our name. So we put credit freezes with all our credit bureaus. That's the one thing we didn't talk about. And I had no idea how to unfreeze the accounts. I wound up going through the bank. They tried to get me to the credit bureau to unfreeze. I failed all the questions they asked, and it took me months to finally get someone to tell me, open your own credit freeze account because your social will tie into those frozen accounts and you'll be able to unfreeze them so you can get a credit check. But if I hadn't had cash on hand, I couldn't have survived those months.
Yeah.
That's the lesson. Make sure you are either a co-owner or a joint tenant with 100% return.
Well, so there's two parts of that on the credit cards. One is whether each each spouse or each of us should have at least one card in our name where we're the first person, even if our other spouse is the second person. And the other is, if you want to go the route of saying, I want a credit freeze on my card to protect from other people trying to use my card or opening up new cards. If you go to that extent, be aware of what it takes to unfreeze them and what happens if the person dies, who's the main person, right?
Yeah.
Two different things. All right. Well, besides having people list their accounts, and by the way, I would never have a client give me a list of where their passwords are. That's nothing I would ever want to have in my office. So you need to give that to somebody else or tell someone where it is or where it's locked up. But we do recommend also making a contact list, an emergency contact list with your close family, with your doctor, with your lawyer, your accountant, your financial advisor, if your kids are at home, your kids' doctors, so that if anything happens to you, people can get a hold of who they need to get a hold of. And I just want to say that there is, in a little bit of connection with this, one thing I learned that I passed along that Bertie Feldman taught me in her class here was that if you have an Apple phone and you have that Heart app for health, then you can go into that, and that allows you to put who your emergency contact person or persons are. And the police and fire department and first responders are able to open your phone up to find out just on that Heart app to find out who your emergency contacts are. And then they'll be able to contact your adult child or your spouse or whoever without a password. They have their own passwords. Did I say that right, Bertie? The health app. To get to one page, that one page in the health app, no password is needed for them because they have their own passwords. Someone, right? Don't the police have their own? Anybody can get it. So something to remember. I've had people be very grateful for that, so that when you carry your phone or you're in your car. And that's one reason also why you want to list who your lawyer or financial advisor is, because sometimes people will know to call that person, and then that person has your other contacts that are needed, including your doctor, which is important. A power of attorney for assets. So power of attorney, there's a number of different kinds of forms. One of them that we've printed as a handout for you, and it's over on the table you can take afterwards. So a power of attorney says that I name someone else, Ricky Barker, as my power of attorney to act for me. And that means that she theoretically can go into banks or do real estate transactions and sign my name to things. So I want to be very careful who I name, if I name anyone, but who I name. Normally it might be a spouse. Some powers of attorney are called springing powers of attorney. We use those a lot, and they only spring into effect if I become incompetent. So if I become incompetent, like have a stroke or get hit by a truck, then, and two doctors say I'm incompetent, is how my forms read, then the power of attorney becomes effective, and the person who I've named is able to sign things for me. My power of attorney documents that we prepare in our office says that 2 physicians can sign to say I'm incompetent, and then I am. That is better than having a court decide I'm incompetent, because a court takes a few months maybe and a bunch of thousands of dollars of legal fees to get into court to do that. So each family is different and each person is different, but I kind of like those because it gives someone the power to talk to Medicare for me, or the power to talk to my phone company for me, or the power to call up Visa to find out what my last bill was. Powers of attorney can be just regular, or they can be durable powers of attorney. We want a durable one, because durable lasts not only while I'm competent, but also if I become incompetent, the power of attorney stays effective. And of course, that's where it's the most important, is if I'm incompetent, I want that power of attorney to be effective. So if you have a power of attorney, take a look. it has the words durable in the title or in the first paragraph or two to be sure that it will in fact last during incapacity. We'll take some questions or experiences as we go, and then some others at the end afterwards. Question? Should you include a time frame in the power of attorney? Well, first of all, sometimes we do. If I say I'm going off to Africa and I'm selling my condo in the meantime, and I want my friend to be able to sign the papers, the real estate papers. So I would say this is only good until February 28th, 2024. Or if but if I come out of a coma, if I want to revoke a power of attorney, I can do that. If I don't like that person anymore, I can revoke the power of attorney. But normally we do not have a time frame on it. I must say that banks and brokers do not like old powers of attorney, even though legally the one that I signed back in 2008 is still valid today. If I never revoked it, a bank will give us so many troubles about using it. They want a new one, new being in the last year or two. So a lot of times I like people to just re-sign every few years. The Advanced Healthcare Directive is our next topic, and I'm going to let Ricky start out on that because she has opinions.
Yes, just so you know, we had in 2010, we did our trusts with our wills and our health directives. And unfortunately, we didn't look at them for many years. When Ernie got diagnosed and was told he was going to die, we, sorry, let me just take a breath. We looked, the hospital told us that California passed an end of life thing to say that if you can vocalize your wishes to die in California, it's now legal to do that. And Ernie tried, but he had advanced so fast, he couldn't vocalize those words. What happens is you have to be able to tell two attorneys that you wish to die. They will have one prescribing who will prescribe the drugs you take, but you have to take the drugs yourself. Nobody can give them to you. When Ernie couldn't make that vocalization, we had discussed before that what is an alternate. And the alternate we came up with was to withhold food and drink. And our hospice care provided morphine. And I would give him morphine drops every half hour to ease him through the transition. What it did for me was spur me when I redid my trusts and my wills and my health directive was to add those specific words to my health directive that if I should become to a point where I can't go on, that I have the right to end my life. Barring that, if I'm unable to vocalize that, I wish to have my food and drink taken away from me with morphine drops to ease me through. And that copy is with my attorney and also with my doctor. And it forces me on a yearly basis to look at the laws to make sure, because I know end of life laws will change over time. And I want to make sure that if somebody can prescribe those drugs to me, that it will be in my health directive. So it's important that you spell out how you want to die. It's not a good topic, but it's so important that you know and everybody around you knows and your advocate knows.
The Advanced Healthcare Directive allows you to name it does two main things. It allows you to name an agent. That is the person who will speak for you of whether to treat you for pneumonia or not, whether to have surgery or not, whether to have the paddles of life done or not. So that agent, you want to name an agent who hopefully will have good common sense and think the way that you would think, and as far as how your treatment should be. The other thing that an Advanced Healthcare Directive has, the other major thing, I think, is those end of life decisions, as Ricky says. I tend to like the general language if you have a good agent who you know will follow what you want. And the California Medical Association language is this: if your choice is not to prolong your life, then the language is this. Because if you want to prolong your life, you say, I want to stay alive no matter what. If I'm a vegetable, if I'm whatever, keep me alive. And you're allowed to sign that. And then your agent is bound by that. And so are the doctors in the hospitals. I do have one client in every 100 maybe who does choose that, by the way, but not the others, and not my doctors for sure, not any doctors. The choice not to prolong life is, I do not want my life prolonged if I have an incurable or irreversible condition that will result in my death in a relatively short period of time, or I become unconscious and to a reasonable degree of medical certainty, I will not regain consciousness, or the likely risks and burdens of treatment would outweigh any expected benefits. So the quality of my life is not going to be what my agent thinks that I would want my life to be. That's what most people choose as kind of a general language, but what it really does is put in the agent named who should make that decision and use that common sense. We name an agent, a backup agent, another backup agent. Some people name their spouse first, their child next, their adult child, if they think that person has a good sense, or their sister or their brother. Some who say, oh, I want to name all my children so no one feels, unloved or anything, that's be equal. And I argue against that. And I say, name the one who will make the good decisions, because you don't want, if you're unconscious, you don't want them fighting over your body and nothing being done and gridlock. So it's really important to name someone good. The other thing, it does also say, if you choose to say that I want to be buried or cremated or ashes scattered or whatever. Otherwise, your agent makes that decision, your medical agent. If you don't have one of these forms done, then the law of California is that your closest heir makes the decision, and that would be a spouse or a child. For people who aren't married, and their closest person is not their closest heir, I have seen doctors in hospitals, I've seen this many times, go to the remote first cousin who hardly ever has seen that person, and that's the one who has to sign the death certificate and sign the directions for what to do with the body. And that's really tragic. So we have a form of an advanced healthcare directive that's also up on this table if anyone wants it later. And any of these forms, by the way, Ricky, if you email to Ricky, then she will email them to you as PDFs and you can have them. These are just some forms. There's lots of different kinds of forms around.
Yeah. And if you go online, you can find thousands of forms for anything that you're looking for. When I was starting this process, I Googled different things and thousands would come up. So what we're giving you today is just a sample of what's available. So, you can do your own, or you can use one that we've put together.
Yeah, Kaiser has one that's good. UCLA has one that's good. Some of these forms, by the way, go into a lot of detail. If I'm not breathing for 3 days, then do that. And if I can't think of something, then do the other thing. And my personal belief is find an agent who you trust their judgment and don't do that. Because if you're a healthy person now, who knows how many days or whatever one should not be conscious that things should be done to you. So I don't like the detailed forms, but that's just my opinion. Okay, and you should give the form, make sure that's the one form you should give to who the agent is, because they don't need your will and your trust and all that, because that's about money. Money can always wait, but your body cannot wait. It can't wait for the weekend when the lawyer is not there or whatever to answer. So that's the one form that you should give to whoever your first named agent is and let them know they have it. And many doctors take a copy of the form. The computers at Cedars-Sinai and St. John's all take those copies in. And so that's a good thing to have done. Does it need to be notarized? the law, California law is it's either notarized or signed by two witnesses. Okay, let's go to money. Talk about bank accounts. Start us off.
Yeah, well, I think I mentioned the fact that when Ernie died, I lost access to that account and had to start my credit cards again. And so that's, to me, that's one of the most important things that you can do is you have to be sure, because we all have our bank accounts, but are you on that account as a co-owner or a joint tenant? If you're not, and your spouse dies, you're going to wind up with nothing, and it's going to take forever for you to get that straightened out. So go to your bank, make sure that you are both owners of that account. Otherwise, you will lose access to your finances. And it's important to keep some money on hand anyway. You know, people tell you have a month's income available. And if I didn't have that money, I wouldn't have been able to survive for the months before I was able to get a credit card. So it's extremely important that you learn this lesson. It's a lesson I tell everybody, that be sure you are on that account so you don't lose access to your money.
Yeah. If, by the way, if you do it correctly or have a living trust or you are on the account, then you might be shut down for 2-3 weeks till you get a death certificate, but then it will be open again. So, and there are other ways to access faster, but just to say it doesn't need to take months. Although if you're not doing it the right way, it can in fact take months. Yeah, question. Hey, so make sure to have someone on your safe deposit box, someone who you trust not to go into your box and take a look around.
Yeah.
Well, no, I don't think that will. So then you're incompetent and you're in the hospital. They come to your house, they get the key, they go in, and oh, that jewelry, the diamond necklace was never there. Only the gold coins were there. So I just think you have to really trust the person. Otherwise, there are ways to get in the safe deposit box legally after someone dies. So trust if you trust someone, bring them to the bank and have them signed again on the box. That's really as good advice. And the banks, I kind of unofficially, stop recording for a minute, say, don't tell the bank that your person died. Sometimes they find out because the mortuary notifies Social Security, and if they do automatic deposits, Social Security notifies the bank, and then they find out you're dead, and then they might freeze the account. Although if you have a very friendly banker, then they will accommodate you. But many of us, even though we say, I've been at Bank of America for 25 years and blah, 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 and I've been loyal, the bank's not usually loyal to you. It's the people who work there who are loyal to you. So I usually don't tell the bank, so that we have that extra week or two to be able to do things and access money. Many times we'll advise to keep that account open for a few months, even like 8 months after someone passes. And the reason is because little checks come through. You know, you change the utilities bill, and so then the LADWP sends a refund check for $75. So made out to the dead person. So what are you going to do with that otherwise? If you have a friendly banker, they might let you slip it in your account. But if it's not a friendly banker, you can try to deposit it back into that account again. So there's a lot of little checks, little dividend checks that come made out to the deceased person that you need to sort of figure out how to handle. If your lawyer has to handle them, it's going to cost more than the $75 check is worth. And many times people have just kind of thrown away those little checks. It's not worth dealing with them. Okay, well, I think we've covered credit cards. Let's go on to ownership titles.
Okay.
Okay. Question?
Yeah.
Was there a joint account on credit cards that you and Ernie had?
No, everything was under his bank. And so even though I had my name on the credit card, it was his account. And when he died, they canceled the cards.
Yeah,
Yeah.
I don't think that there are joint credit card accounts. There's joint bank accounts, but on credit cards, I think only one name is on a card, even if you have another card issued for your child or your spouse.
But if you're on the bank account as a co-owner or whatever, then your credit cards won't be canceled. It will only be canceled for that person.
So ask your bank, whoever your bank is, you can go in with some questions and ask someone who's knowledgeable and not just hired last month. What happens if I die? What happens to this? Is it frozen? Can I sign? Can my spouse sign? All right, so we're getting into ownership titles. Joint tenancy, which is very common, joint tenancy of 2 people or even 3 or 4 people means whoever survives gets it. And joint tenancy, you can tell it's in joint tenancy, a bank account, broker account, real property. If it says Vicki Magnuson or Ricky Barker, or means joint tenancy. If it says Vicki Magnuson or Ricky Barker as joint tenants, or by survivorship, all of that says joint tenants, and whoever lives longer gets it. It's very easy as a way to transfer title. Be careful of that for real property because of capital gains and stepped up basis things that we might not get to today. But I'd say for bank accounts, it's a really good idea, as long as you don't mind who gets it later. There's another thing on banks and brokers that sometimes if I have an account in my name, they will allow me to name a beneficiary. So that it's my account, but if I die, then I name Francine Nicholson, my daughter, as the beneficiary. Sometimes that's a POD, pay on death. Sometimes it's a TOD, transfer on death. It all means the same thing. Francine has no rights as long as I'm living, whether I'm competent or not competent. She has no rights. But if I die and she shows a death certificate, she can come and collect that account. So for some people who have no real property and a pretty simple estate and all they have is bank accounts, naming beneficiaries or pay on death, transfer on death is pretty easy. Co-owners of accounts. Okay, so we already heard Ricky's story about being co-owners. I would, if my spouse and I are co-owners and both of our names are on and it says and, then it might be, it doesn't go to who survives. It's if I'm surviving, I have half, and the person who died, their half is stuck. And I've had banks who say, no, we can give you your half, but we can't give you their half. And so their half, what do we do with that? Well, it throws us into probate or some kind of probate style thing because it's stuck. And we'll talk about things being stuck. So again, check with your banker or your broker and see what happens if it's joint tenants or if it's or if it's and, because if it's me and this other person, then the one who died, their account is stuck in their name. Question, Bertie? We haven't talked about trust yet. Okay. Let's talk about, okay, so credit cards we've talked about also, passwords we've talked about. I want to talk about car title and boat title. So car title, a lot of time, so I might have my car in my name. I could have it in my name and my spouse's name. Usually it's or at survivorship. That's how most people have their cars. Unless you have a investment car that you keep and that's worth a lot of money, but if you have a car that you drive, usually I recommend it be in your own name and not in your living trust. It's just easier to have the insurance coverage, and easy is good. If I die and it's in my name, just myself is all, then so let's have Ricky be the one who dies and I'm living. I I'm a member. Is that okay?
Yeah,
Okay.
I just died.
Okay. So I can get her pink slip, get the car, and go into AAA because I'm a member of AAA and tell AAA that my good friend Ricky died and that she left the car to me. I tell them that. And AAA will say, fine, oh, good, sign these forms. Oh, and I need a death certificate. So you died. I don't need a will to show them. I just tell them. And so then I sign some forms and I have ownership of the car. Okay. So it's really easy to pass a car when someone dies. I have no problems with it being in your name or being in joint tenancy name. Boat title, again, that can be in the trust because it's a more valuable if you have a living trust, or in joint tenancy. I have never in all my years had to help someone transfer boat title after someone died, whether it's with DMV or whether it's with documentation. So my guess is that it's not hard to do, but I've never had to deal with that before. Okay, so let's change now. We're talking about our overarching theme right now is how to pass things to who you want them to pass through and how to avoid probate court. Let's talk about personal things like jewelry, art, furniture, collections, trophies.
Yeah, and that's where I can step in. In 2017, I had an aneurysm and almost died. And when I came back in 2018, I realized that I had a whole area for my jewelry. I had many things that I needed to pass on because I knew how terrible it would have been for Ernie had he had to go through all this. I sat down and made a list of all the things that I needed to be given away. I included the names of the people, their addresses, and wherever possible, their phone numbers. And that resided, I told him where to find it, and I kept a copy with all our paperwork. I didn't look at it again until after he passed, and I realized from 2018 to present, I hadn't even looked at it, and I'd gotten rid of so much of the stuff that was in this document. So I now have updated that, but that's why it's super important that you guys look at what you've done, because all the good intentions go away because you don't take the time to keep reviewing things because it's an uncomfortable subject. And so make sure you put your personal goods. When Ernie died, I was covered with grief, and all I could think was, let me get rid of everything that reminds me of him. And I gave away things that I wish now that I had saved. And I had to learn the lesson that if you're going to do something after your significant other passes, give yourself some time, wait a week, wait a month before you make a decision, and let your advocate or a family member tell you what you should keep and what you should give away. But when you're in grief, you do a lot of dumb things, which I did a lot of dumb things in my grief. So
you open up a couple of things I want to comment on. So
Okay.
about the dumb things part. So I would say that when a spouse dies, your brain gets just more fogged and you go slower, and it takes a number of months before you stop having what seems like dementia but isn't really dementia. And I know it happened to me, and it happens just to everybody, and so you need to give yourself that space. And so what that means is wait for decisions. I mean, the old thing that everybody says is don't make big decisions, don't sell the house for a year, blah, blah, blah. So, but that is pretty good advice in general, is don't sell the boat, don't sell the house, don't give away everything right away the next day and say, I'm clearing out everything, because you can have regrets. So just give yourself some time to think about it and step back. okay, so personal property lists. I know so many people who put little yellow tags on things and say, this goes to my niece Melissa, and this, yeah, you know, people who do that too, and this go. So that always just astounds me, because all that someone has to do is come into your house when you're in the hospital so sick and go change what goes to who. I mean, it's what a what, I don't know how that cannot occur to people that happens. So so little tags are okay, but back it up with something. So I agree with what Ricky said. So if you have something, you've said, oh, my grandfather clock was always going to go to my grandson this, and my necklace so-and-so was going to go to that. So make a list. Do look at it from time to time. The law in California in general is if something is on a list, but you don't own it anymore, it's deemed to disappear. You don't have to give money to someone instead of that. But I would make a list that's up to date. Now, make sure the list doesn't conflict with something else. Like, for instance, in most living trusts that I've done and that I've seen from other lawyers, it says that personal belongings go according to a separate list that's made. And if there is no list or something's not on a list, then it goes to my children equally, or it goes to whatever. So make sure that it doesn't, because if your trust or some other document says all my personal belongings and all my jewelry all go to X, and then you have a separate list, well, that's probably a lawsuit waiting to happen. But I won't even tell you who I think would win that, but you don't want to put people in that position. So make sure it goes together. And but otherwise, I love the idea of lists, and it probably helps out trustees. I've been in people's houses more than once. We're waiting to call the police because we're worried about the kids and how they're going to decide on things. And because they're fighting so much and they can't decide who gets the silver and who gets that and who gets the other thing. And so it's good if you know who should go get what to do that. Sometimes people who are more elderly have their family come in, and you just put the jewelry out on a big white sheet and you say, you have things in mind that you think you want, tell me what you want, I'll put it on my list now, and then you'll get it. So you can think about whether that makes sense for you or not to do. Okay, so we've been talking and dancing around things getting stuck and about probate. So what probate is it's a court procedure. So if I die, who can sign my name, Vicki Magus? My power of attorney doesn't work anymore. If I'm not alive, power of attorney ceases to be effective. So who can sign my name? Well, no one can sign my name if I'm dead. So if I have things that are stuck in my name, like a bank account or brokerage account or my home, then the family or whoever is in charge goes into court with a petition to open probate up and have the judge appoint an executor or an administrator who is able to sign my name. And then that executor can go to the bank and say, I'm Vicki Maguson's executor, and I want to collect her bank account now and put it into the estate of Vicki Maguson and have it be overseen by the probate court. And so that's what probate is it's a judge overseeing my assets after I die, if they're stuck in my name, because no one else can sign, and overseeing it. In probate, there's a list of what my assets are and what they're worth. And then if there's a will, if I left a will, the judge will oversee that the assets go to those people who are named in the will. And if I didn't leave a will, so that I'm intestate with no will, then it will go to my closest heirs, which might be my children, even though I have a significant other that maybe I would have left things to. Or if I have no children, it could be my remote second cousin who I never have talked to, even though I have good friends. I mean, this really happens. People, as you said, don't want to think about dying, which you should think about while you're healthy. Take care of it, do it, and then don't think about it. So, yeah, so that's probate. It takes about a year at the fastest, if the lawyer does the right things and the client does the right things, and if there's no litigation, because if there's a family who might sue each other and disagree, probate is perfect for suing because all the notices go out to everybody. And it's almost like the judge says, come on in and talk. If you want to talk, come on in. This is your opportunity. This is Tom Mullally knows about this. So through and so probate takes about a year. The basic cost for publication in a newspaper, filing with the court is around $1,000. The legal fees are around 2 to 3% of the gross value of the estate. We don't take off for mortgages. And I put an exact amount down on the outline. And the executor is allowed to charge the same as the lawyer is. So figure 2 to 3% to the lawyer, 2 to 3% for the executor. And that's what we try to avoid, the time and the costs of probate when we talk about living trust, which we're going to talk about now, or about the joint tenancy by survivorship or the pay on death. So a beneficiary gets it. All right. If I create a living trust, I am the creator, the trustor or grantor, and usually I'm the trustee. Also, I manage my living trust. But and my living trust can be amended anytime or revoked or changed, and it uses my social security number. So I don't change my income taxes at all. But whatever assets are in my living trust, Magnuson Living Trust with Vicki Magnuson trustee, whatever says that, if I die, my next trustee, let's say my daughter Francine, comes in with my death certificate and she is trustee now, she manages it, and she can take over the bank account and the brokerage account and the real estate and everything. She can take over as trustee. So we don't need a judge to say who's next or who gets anything or who oversees it or those kinds of fees that we talked about.
And we should mention that there are two kinds of trusts. So you want to make sure that you have a revocable trust, and otherwise you can be locked into that trust. It's revocable and what?
Well, a normal living trust is revocable while I'm living. Mm-hmm. When I die, it becomes irrevocable because only I can change it. The irrevocable trusts are things that we do for people who want to make gifts to their children or do something irrevocable, which is beyond today's topic, which is another kind of tax planning. The other thing a living trust does is if I became incompetent, I got hit by a truck, I'm in the hospital, Francine, as the next trustee, can get two doctors to sign something to say that I'm incompetent to make financial decisions. And then she, as trustee, can go in and take over my bank account and pay my bills for me. And so that's really very important as a transition.
We were going to talk about the estate taxes.
Yeah, I just want to say one more thing about privacy, about a living trust. 1 second. Privacy. So when someone dies who's famous and you know how much they had and who they left it to, is because they're going through probate. If you have a living trust, everything is private, nothing is in court. And if my family decides to sue each other because they want to contest my trust, that will go and become public. But otherwise, it's all private. And it helps to avoid litigation. I tell people to review their living trust along with their personal property and health directives every 3 to 5 years or so. Question. A living trust continues during my incompetence and my death, and someone else steps up to be the trustee, who's the fiduciary who manages it. The power of attorney is a separate document. And in fact, if you have a living trust, and if my brokerage accounts, my bank accounts, my home are all in my living trust, that means usually that the power of attorney agent doesn't deal with those things. So then why even need a power of attorney? The answer is the power of attorney is who can speak to Social Security about changing where my check gets sent. The power of attorney is who can talk to Visa about my bills, anything personal. But my assets are on the living trust and the trustee controls them. That I'm incompetent. Mm-hmm. Okay. So what if what if what if the trustee gets two doctors to sign that I'm incompetent, but I'm really not incompetent, and they take over my assets? Well, that's a good lawsuit waiting to happen. And it's not only against my trustee, but it's against those doctors who signed who shouldn't have signed. So my experience with doctors is that they would never touch this or sign to say that I'm incompetent unless I truly, absolutely, really am. If I'm just forgetting things and tipping my hairdresser $300 instead of my normal, that's not, a doctor will not say I'm incompetent. One more question in the back. Okay, so boats, if you're documented, a boat can be in the living trust. So I would recommend it. If you have a living trust and you have a boat, do that. And again, it's really easy to work with the Coast Guard. I've not had clients had me do it for them because they can do it just as easily as I can do it. If you have a car, as we mentioned before, I kind of like it being in your personal name because it's just easier. I want your insurance to be really clear that it covers you for car accidents. But if you have another 2, 3, or 4 cars and they're investment cars, then they can be in a living trust because they're investments and you're not driving them continually. Question here. Is it legal to put in your trust that anyone who contests my will or my trust gets nothing? So we always put that provision, that no contest clause, in our wills and trusts. If anyone contests this or they contest my beneficiary of my IRA, then they get nothing. But the laws of California in the last 10, 15 years have gutted that provision. And it means, it says, so the law says if someone has good reason to question it, then they might not be omitted by the no contest clause. So it's become much more complicated to question it. People are not as afraid of questioning anymore, but it still gives them pause because if I've left nothing to someone anyway, what's the big deal? They can go ahead and be litigious and question it. But if I left someone $10,000 or $100,000, they might think twice about questioning it because they would stand maybe to lose that. Leaving them $1, by the way, which a lot of people come in and say, oh, I'm going to leave $1 to my nephew because he's just awful. And I go, oh, no, no, no. We're not going to leave anything to them because leaving $1 makes him a beneficiary to get notices and everything. So we are not, we don't leave $1. That's only on TV. Richard? Yeah, well, all right, cars do not count in that amount. I'm going to get to the amount in a minute, but cars don't count in that amount to avoid probate. And the boat, as I've said, if you have a living trust, register the boat in your living trust. Okay. Okay. Let's go to, so beneficiaries, avoiding probate. So we talked about joint tenancy, life insurance policies, those name beneficiaries. You can't believe how many people got their life insurance like from World War II or something, and they named they never changed their beneficiary. They don't know who it is, or they got it when they were married to someone else and they never did change it, which by the way ends up going to that person who's named. So So one of the things you should do when you list your assets is list your life insurance, make sure who the beneficiary is and who the contingent beneficiary is, the backup beneficiary. So many times we have a spouse named as beneficiary, and when the children are little, we might name the living trust as the backup beneficiary so that it will protect the money for the kids. When the kids are grown up, we name the kids directly if that fits into the estate plan. But make sure you have a beneficiary and a contingent, and that you know the life insurance company has those wishes, because life insurance companies lose papers from time to time, and you want to make sure you have a copy of that in your records. Same thing on IRAs, 401ks, retirement plans, Roth IRAs. Make sure you have a beneficiary and a contingent backup beneficiary named on them. And they don't go through probate because they go right to the beneficiary, just showing a death certificate. Annuities, which is a whole other animal. Every annuity is different. I'm not an expert at all on annuities. I'm not a big fan of them either, but make sure who's the owner and who's the beneficiary and the contingent and what happens if you die and what the income tax impact is. And so ask your advisor who sold you the annuity how you do that, and make sure there's always a backup beneficiary so that it doesn't get stuck in your name and have to go through probate. Now, estate tax. Are we okay?
Yeah.
Okay. So one more question. There's a Jarvis commercial on the radio. Well, it might be about property tax, but there is no, okay, so I don't know what that is that's on the radio that you see or the TV. What I will say is California has no estate tax, no inheritance tax now. And the voters voted it out around 1980 or so. We used to have it, and sometimes it'd be more than what the federal tax was, but we don't have any here. So that's that. So all we have is the IRS estate tax. And the IRS estate tax, the credit equivalent right now is $13.6 million for everyone who dies. So if I die, I can own up to $13.6 million and there's no estate tax. And my spouse can own $13.6 million with no estate tax. Okay, so the number is much higher. It used to be $600,000 last time I gave this talk. So it's really high. And if there's and plus, if you leave things to a spouse, you can leave them whatever you want for free, $50 million or whatever it is, because Congress likes spouses, and you can leave things to a spouse or in trust for a spouse for free. Plus, you can leave things to charities for free. So that's the estate tax rule. It used to be that we would have complicated trusts. We called it an AB trust, or when a two-part trust. So when one spouse dies, your living trust divides into two parts so that your kids can get the advantage of the full $13 million for each of you. But Congress a few years ago changed that, and they said, we don't want to make people go to expensive lawyers to get these two-part trusts to save money for the kids. So therefore, we're going to allow people to elect to have their estate tax credit be portable when they die. So let's say I die, I'm married to Bob. I give everything to Bob when I die. My 13 million goes to him. Well, I've kind of wasted my credit because it goes to him for free anyway, because he's my spouse. But what the portability law is that if after I die, Bob files an estate tax return and elects that my unused $13 million be portable to him, then no estate tax when I die because it all goes to him. But that portability means when Bob dies later, he's got my $13 million unused tax credit that he can claim for his estate. And he has whatever the law says his amount is, it's 13 million or whether it's 6 million, whatever the law is at the time he dies. so that his family is protected for all of that. So it does double the amount of the estate tax credit in the same kind of manner. Some people who have old two-part trusts are opting to change it back to the kind of trusts we had in the 1950s and 60s, like I call an I love you trust. It's one, it's I give everything to my spouse if I die. And I know my spouse will do the right thing and take care of the kids, or my spouse will do whatever they want. That's okay. We earn that money together. And so we can make it much simpler when one spouse dies. Some spouses like the two-part trust, even though for estate taxes, they don't need it anymore like we used to have it, but they like it. And the reason they like it is we call the other trust the anti-floozy trust or the anti-gigolo trust. Well, you know just what I mean. Okay. So that my half can be held for Bob as long as he lives and give him the income from it. And it might even make him the trustee to manage it. And maybe he can even get into it for his support needs or health needs. But when he dies, it doesn't go to his new floozy or whatever. Okay. So, so people like that sometimes. That's okay. So that, okay. So one more thing about estate tax is that it's changing. It's going up with cost of living. So right now it's 13.6 million. It's going to go up to around 14 million for people who die in 2025. And then it goes back to the old law in 2026, because when the government passed this law allowing these high estate tax credits, the budget office only scored it for, I think it was 8 years, and then it goes back to the old number so that it wasn't as expensive for them to be able to pass it. And so the old number is more like 6 or 7 million each person, like 7 million me and 7 million my spouse. So we'll see what Congress does when 2025 comes, if they do anything, or in 2026, but that's what the discussion is. So when you see this in the newspapers, you'll kind of know what they're talking about. Okay. So people are going to get really nervous in 2025 if they have estates, a married couple of more than 6 plus 6 million, let's say. My personal thought, and those of my colleagues, is that Congress will somehow manage to keep the current amount, these 13 or 14 million dollar numbers. And the reason is because they have that much money. And so, but we'll see. Congress is hard to tell. All right. So we have another handout for you, which is called a statutory will. I just wanted to mention it because it exists. So this California State Bar wanted to help out people who had sort of simple estates, I guess, to take care of doing a will. Now, a will, of course, speaks at death. A will goes through probate. A will is only effective when, after someone dies, you give it to the probate court so the probate judge can oversee it. So you're opening up a probate when you do a will, instead of doing joint tenancy and beneficiary and living trust and stuff like that. But it does exist, and so you can get the handout up there, or you can go on the California State Bar website, and it says who you name to get things. It even can deal with parents of little children. I don't so much recommend it, but it's fine. It fits for certain circumstances, and it does exist. And I want you to just know about that if it helps you. Okay. I think, there's one more handout that we also have if you want to get it, which is a post-death checklist handout. I write a newsletter every year we should send out to our clients. And the one I wrote in early 2023 is about post-death checklist and what to do when someone dies, and how we have to give notices to beneficiaries and how to collect assets and so forth. So if you'd like to have that, you can get that. Now, let's go on some. All right, Ricky, I'll turn it over to you.
Yeah, I think now is about the time to really think about the future and how you can stay organized. When we go through this process, what happens is, no matter how organized or logical you are, your grief is going to interrupt everything. And it's important that you select someone you trust to work with you and be prepared to step in when the time comes, because so many things will come up that are unexpected. And, you know, during the time that you're going through this, when your significant other dies, you're going to be inundated with people calling you and stopping by and asking what they can do to help you. And it's up to you to think about that and be prepared. Someone mentioned to me that if somebody says, "What can I do to help?" instead of saying either nothing or this or that, make a suggestion that they contact you in a few weeks or months just to check in with you and see how you're doing. Because life goes on and all the calls and the stops will go away because people have to live their lives. It's up to you to make a plan for your future, to really sit down and say, if I'm alone, what am I going to do with my life? And for me, what I did, my thought was, I'm going to live life to the fullest, because I'm sorry, that would be what Ernie wanted. I made a vow to be with people, to say yes to any invitation I got, and to be as active as I can, because that was the best way to honor my husband. And it's so important that you live your life and you live it in a wonderful manner for your husband, spouse, or significant other. So I'm not really sure what else to that, but it is important to live and be happy for your spouse.
I, you know, Ricky, when we were preparing for this, there were many teary moments that we went through, and I'm really, it's very unusual for someone in this state to really open up and try to help others with facts and not just a little chit chat. And so I really thank Ricky for doing this, and I'm glad I could.
Well,
help.
I've got to thank Vicky, because if it hadn't been for her, I never could have gotten this class together. And it was such an important class to have, to let as many people know as possible what could be done and what should be done. So I do want to thank you. Thank you so much, Vicky.
You're welcome. I'm glad that so many of you came, because it's really important to do this while you're healthy, take care of it, and then move on and forget about it for a few years. I hope you took some good ideas. Thank you all for coming.
Thank you.
Ask Joel Leslie.